Hi, today I'm going to talk on behalf of the community of road accident victims in Queensland. Over the past few years, Queensland deaths related to road accident have been rising and has the highest number in the country, claiming 18% of total deaths on road in Australia. Being concerned about road deaths and safety is imperative as it encompasses a profound range of consequences. First and foremost, it's about preserving human lives and preventing injuries and disabilities, sparing families and communities from enduring unnecessary tragedies. In 2020 to 21, approximately 18,000 people were hospitalized because of road-related injuries, which is a very concerning number because so many lives get affected because of this issue. Moreover, the economic toll of road accidents, including medical cost and property damage, strains healthcare systems and diverts resources. Some of these accidents include circumstances when an individual suffered harm due to the negligence of another person, and these circumstances, the law of negligence, is applied in Queensland. To make a successful claim, the injured road user, it could be a pedestrian, cyclist, a motorist, or a passenger, must prove that the defendant breached their duty of care by failing to take reasonable steps to prevent harm, that the breach caused the injury, and that they suffered harm or injury as a result of the breach. There is a fundamental issue within the system relating to personal injury claims, that is, the victims avoid going to the court for a fair trial. Instead, they choose out of court settlement. Only 1% of personal injury claims go to the court in Queensland, and the rest are settled by discussions between the parties and their lawyers outside the court. Australia has a blame culture. People do not take adequate responsibility for their own actions. As a result, defendants do not pay the right amount of compensation to the victims in negotiation out of court. The number of out of court settlements is drastically high because it is generally cheaper and faster to negotiate a settlement out of court. More than 30% people say this thing. The victims perceive going to the court to settle a claim a risk because if they lose the case, they will end up with lesser money than they would have had if they negotiated a settlement. The law is designed for both the parties to negotiate in the court, and the court may give a 100% reduction of damages depending on the situation. Injury lawyers generally have a no-win, no-fee policy, which leads the lawyers in pressurizing and pursuing their clients to settle for less money just to get their fees instead of focusing on the maximum compensation. As discussed above, there are many people who go through injuries by road accidents, so reforms in this area are necessary for the society so that the victims are well compensated. Most people who suffer injuries on road due to negligence of a third party do not receive compensation from the tort system as they go for negotiation out of court. An analysis of the tort system will further be provided in the presentation to help the victims be guided through the process of the court, which might make the victims inclined towards depending on the courts to get compensation from the defendant. A tort requires that the defendant owed a duty of care to the plaintiff, and that duty was breached, due to which the plaintiff suffered harm and the harm was caused by the defendant's actions. To establish a successful claim, the plaintiff must show that the defendant owed a duty of care towards them and they breached their duty, and the cause of the injury was due to the breach by the defendant. The duty of care owed by drivers on the road owe a duty of care to the passengers, pedestrians, other drivers on the road. In this landmark case, the plaintiff, Pennington, was injured in a car accident when the defendant Norris negligently collided with a vehicle. Pennington suffered severe injuries, including a broken leg, as a result of the accident. She brought a personal injury lawsuit against Norris seeking compensation for her injuries and damages. The central issue in this case revolved around the standard of care owed by drivers on the road. The High Court of Australia held that Norris had breached his duty of care to Pennington by driving negligently and causing the accident. The court also emphasized the principle of ordinary reasonable care which all drivers must exercise on the road to prevent accidents and harm to others. Proving a breach of duty by a driver is a crucial element in personal injury claims or civil lawsuits related to traffic accidents. There are two major parts to establish the breach of duty. First is if the driver did not maintain the standard of care that he owed. The second one is to establish did the defendant's actions or omissions breach the standard. This would even include negligent behavior. If the was foreseeable, it was not insignificant, and in that circumstance, a reasonable person would have taken precautions that would establish the breach of duty for the defendant. Section 9, subsection 2 further describes what precautions a reasonable person should have taken to prevent the breach of duty. To establish causation, there should be more than 50% chance that the defendant has caused the damage and the onus of proof is on the plaintiff. Section 11 of the Civil Liability Act is the test stated by the High Court to satisfy the requirements for causation. Factual causation and the scope of it has to be visible to prove the breach of duty caused by the harm. Cause in fact, also known as but-for causation, means that the defendant's actions were a necessary factor in bringing about the plaintiff's injuries. To establish cause in fact, you must satisfy the but-for test, that the plaintiff would not have suffered injuries if the defendant did not do that particular action. The court system allows for the defendant with defenses in personal injury cases by methods like contributory negligence. Example of this is Butterfield versus Forrester, 1809. This defense asserts that the plaintiff's own negligence or carelessness contributed to their injuries. In some jurisdictions, this defense reduces the plaintiff's recoverable damages in proportion to their degree of fault, as seen in Tabbitt versus Gett in 2010. In some cases, there might be a third party involved, so the defendant can rely on that defense as well. Also, if the plaintiff is doing an activity on the road which presumes inherent risk, then the defendant would not be liable for their acts, as seen in Queensland versus Kelly, 2015. Compensatory damages for the injuries would be provided to the victims if they successfully establish the claims by the process mentioned previously. The damages will be provided for the circumstances mentioned in Section 51 of the Civil Liability Act. Pain and suffering damages are awarded to compensate the victims for the physical and emotional pain, suffering, and loss of enjoyment of life caused by the injury. The amount of general damages can vary, depending on the severity and permanence of the injuries. Section 54, Assessment of damages for loss of earnings, states it must be limited to 3 times average weekly earnings. The information in this video will help people as a guide to claim their damages for injuries through the court and not being misguided by injury lawyers to settle for less money. If the circumstance of the injury on road satisfies all the elements discussed, they should go to the court to receive maximum compensation. This would bring a reform in the society in trusting the judicial process in such situations. Further reforms that we need in our society is that the judicial system should treat such cases with priority and appoint more judges in the system to be able to achieve so. Along with this, they should take action against lawyers who pressurize victims to settle for less amount. It is a lawyer's duty to act in favor of their clients, and engaging in such practices damages the faith of people in the whole legal system. As discussed in the beginning, there are almost 18,000 road injury incidents happening every year. So many of these victims would be in the situation because of another person's fault. So the society should be aware of the tort procedure in the court.